Well, hello, everyone. I am so delighted to be here. I can't believe it's the 8th annual symposium from New York Law School, Alternative Dispute Resolution. And the title is particularly apt this year, Diversity, the Continuing Challenge. I'd like to thank Dean Anthony Crowell and Professor Phillips, of course, and the American Arbitration Association, which has acted as a partner with the New York Law School in this effort for many years. And in particular, its president, Bridget McCormack, and vice president, who we've already heard from, Jeff Zano, and of course, the firm of Young, Conaway, Stargatt, and Taylor, and in particular, Bill Johnston, who has served in the leadership of the ABA business law section and many other roles, and whose firm is devoted to the cause of diversity and inclusion. Well, according to one report, about 80% of American private sector non-union workers will be required to use arbitration to settle disputes this year. Think about that. With companies increasingly using employment contracts to bind workers to resolve employment disputes outside of court, it is even more important to have those claims heard by arbitrators who reflect the diverse backgrounds and life experiences of the U.S. workforce. In response to this growing need for diversity, major arbitration firms like the AAA, JAMS, and the Institute for Conflict Prevention and Resolution have been stepping up their efforts. For instance, the American Arbitration Association has embarked on a commendable journey towards greater inclusivity. At the end of 2022, AAA reported that its active panel members were 30% women and 41% ethnically or racially diverse. JAMS has reported that more than half of its employment and labor-related disputes are now handled by diverse panelists. These figures are encouraging, but they highlight the distance still yet to be traveled. The journey toward diversity is also about the selection, engagement, and empowerment of these diverse voices in the alternate dispute process. Given the still ongoing concerns about the lack of diversity in the arbitrator corps and the arbitration's already less formal structure, one method for enhancing its legitimacy among diverse disputants is to ensure greater diversity among those empowered to make decisions. Increasing diversity of neutrals rosters, and more importantly, of the arbitrators ultimately selected from those rosters, improves the public's perception of the fairness and impartiality of the arbitration process. How do we accomplish this? Well, we must develop robust mentorship and training programs for arbitrators from underrepresented backgrounds. These programs will equip individuals with the necessary skills and provide a platform for meaningful opportunities and exposure. We also need a proactive approach to recruitment, actively seeking out arbitrators from diverse racial, ethnic, and gender backgrounds, ensuring they are influential voices in the decision-making process. We should also implement regular evaluation and feedback mechanisms so that our strides toward diversity are not only well-intentioned, but effective and impactful. At the American Bar Association, we have taken several steps to improve diversity and inclusion in the ADR process. A few years ago, we passed a resolution that urged providers of domestic and international dispute resolution to expand their rosters with minorities, women, people with disabilities, and people of diverse sexual orientation and gender identities, and to encourage the selection of diverse neutrals. The report accompanying this resolution acknowledged the significant efforts of dispute resolution providers to increase the diversity of their rosters, yet it noted, unfortunately, that diverse neutrals remain underrepresented. The ABA section of dispute resolution, which I hope all of you will join, has taken many steps to implement this resolution. Its Women in Dispute Resolution Committee and its Diversity Committee are both incredibly strong with over 600 members, and the section annually publishes 2 directories to assist those interested in selecting diverse neutrals: the Women in Dispute Resolution Directory and the Diverse Neutrals in Dispute Resolution Directory, which you can find on the ABA website. These directories provide and promote diverse arbitrators, bringing fresh perspectives to old problems. We have also launched an ambitious diversity and ADR internship program and made a commitment to promoting diverse ADR professionals. Our goal is to ensure that the arbitration process reflects the society we live in, where everyone can see their realities and experiences reflected in those who arbitrate their disputes. This is the essence of justice, a system that recognizes and respects the diversity of its constituents. We hope that the our ADR resolution, subsequent efforts by our dispute resolution section and other practice groups, work throughout the profession, and conferences like this will encourage all stakeholders to act. We must constantly challenge ourselves and take concrete affirmative steps to make the change we want to see. We need to continue to highlight the lack of diversity on neutral rosters and the special challenges created by the combination of the network-based culture within the profession, implicit bias, and the lack of transparency that obscures the degree to which dispute resolution lags behind the legal profession as a whole. We must encourage and engage all stakeholders to increase representation of diverse neutrals on rosters and to enhance their likelihood of success in the selection process. As you listen to the conference today, I encourage you to reflect on the rich experiences and perspective each of us brings to this conference. The faces in our field are changing, and they will shape the future of ADR. Let's lead the way together in this transformative journey and create a framework where fairness is inherent, where diversity is not just an aspiration, but a fundamental standard in our practice. Thank you so much for having me today, and wishing you the best for a successful symposium today.
Thank you so much. I appreciate that. And, I'm taking notes, and I've learned so much just from that. You talking to us for, just a few moments. Do you mind if I just have a couple of questions? Do you have time for those?
Oh, sure.
Okay. And so you talked about the increase of ADR, right? We have more arbitration than ever before. A lot of state courts and federal courts have growing mediation programs. And so this field is growing. You talked about the need for mentorship to help people get those skills, for recruitment to get people in the door, and for these directories that help get the word out about women and diverse neutrals. But something you mentioned early on was that, as many people as we can get in the pipeline, we still have to have the selection of diverse neutrals, right? Like people still have to look at this roster and make this choice. Do you have any thoughts or suggestions for for firms out there, for people in the private sector who are thinking about, how do I kind of diversify the neutrals that I'm using? How do I think about that?
Well, I think I have also been an in-house counsel and had to help pick rosters. And I would encourage anyone who has to do that. You get a list of names and you look at the backgrounds of people, and I would say be thoughtful, take a little bit of time, and don't, I think, go with what some of our biases that we have, that certain people might be better for our case or the particular matter at hand, and be thoughtful, because all of the lists that you get, everyone's qualified, and it's so important to have diverse voices. And with our workforce and our population becoming increasingly diverse, it's just even more imperative.
Mm-hmm. So what I'm hearing you say is that people should, I guess, get outside of their comfort zone. I think I heard you
Yeah,
say that
that's
at
a
one
great way
point
to
too.
say it,
I think you
Genesis.
said that. Get outside their comfort zone and pick someone, and that the people that are on that list are all qualified.
Yes.
Right. And so you're probably not going to go wrong. But based on your background in that in-house counsel, people are thinking, okay, I agree with you. But that said, this case is worth millions of dollars, and it's a risk. It's a risk to choose someone that 5 people in the firm have not already worked with, right? And how do people, what do you tell people when they're to encourage them to take that risk?
Yeah, well, I mean, I actually did this when I was in-house counsel. You know, particularly if you're not at the C-suite level or the GC, which I wasn't when I was in-house, you might not be able to persuade the people in the C-suite to go with someone they don't know for the whole bet the company case. But you know what? Every organization, every company, they have lots of cases. And so you might start with some of the smaller cases or the more routine cases. And I did that even in a big case. This was not arbitration, but I had a big multi-district securities litigation, and we needed hundreds of counsel literally for that case to represent different witnesses. And I was able to diversify our outside counsel through that mechanism. So if you want to do it, you can do it.
Right. I mean, what I'm hearing you say is that there are opportunities not just on the big cases, but some of the smaller cases too, and some of the cases that need a diversity of interest, that there might be some opportunities there, and that you can incorporate that as you move up the ladder. You don't have to wait until you shoot to the top to think about some of these changes. They can be a part of the work that you do at any level.
Yeah, it's a journey, not a destination. So any inroads you can make, and just each time you get to push it a little bit farther.
Great. And I'm just looking at the chat, and some of them are coming in just to me, and some of them are coming to everyone. But you know, someone said, "Thank you for your insightful and encouraging presentation." Someone from the Mohawk Tribal
Appreciate
citizen.
that.
Janice, could I offer one quick related thought?
Of course.
If you don't mind. I was just going to offer the thought that I think we as arbitrators have an opportunity to really promote this. I mean, certainly if we run into conflicts, we need to think broadly about who we can recommend as arbitrators. And then likewise, if we're having an opportunity to serve as a so-called wing arbitrator and select a chair, that can be another good opportunity.
Exactly. There are so many ways to open that door, and to bring people in, and to make sure, you know, talented people are getting that opportunity. And they're often it makes for an engaging and thoughtful experience for everyone. Great. Thank you so much, Phil. Well, Mary, I think we're gonna wrap up, but is there anything else that you want to share with anyone?
Well, no, I just encourage everyone to think about, you know, all the different aspects, building the pipeline, the selection, and ultimately, you know, who's chosen. And so thanks so much to the New York Law School and you, Genesis, and everyone involved for bringing this important issue, particularly, you know, as the Dean mentioned, following the Supreme Court's affirmative action decision last year, which, you know, it was the decision itself was addressing higher education, but that decision is going to have ripples in all aspects of legal practice, including alternate dispute resolution and ADR. So these conferences, these type of symposium are even more important.
Thank you. Thank you so much, Mary Smith. And thank you so much for spending some time with us today. We all really appreciate it.
Thank you.
Thank you.